May it please the Court, my name is John Albano. I'm here on behalf of Putnam Investments and Putnam Investment Management, LLC, with me as Carol Head. The judgment of the Superior Court should be affirmed for two reasons. First, Mr. Eigerman's breach of contract claim would require the Court to rewrite Putnam's equity partnership plan. His second claim would require the Court to rewrite the common law as it exists now on the breach of covenant of good faith and fair dealing. The intimidation and coercion that Mr. Eigerman says resulted in a breach of contract, if I could address the breach of contract claim first, arises solely from this memorandum by Mr. Lasser. Every alleged wrongful act is within the four corners of that memo. There are no allegations of threatening phone calls, whispers in the halls, raised eyebrows. Everything is within the four corners of that Lasser memo. And what the memo says is that the company is adopting an informal policy for employees who hold stock granted to them under the plan to hold it as a long-term incentive. This is stock that Putnam had no obligation to repurchase. And it asks that before you sell, unless you're selling to cover a tax liability, please talk to your operating head about the reasons you want to sell. And we've said in our brief that an allegation that a plaintiff divined an intimidating threat from a memo like that should be reason enough for the case to be dismissed. But even if you assume, as the appeals court did, that an intimidating message could reasonably be read from that memo, there is still no breach of contract claim. Mr. Eigerman says the memo intimidated him and coerced him into not tendering his shares.
Excuse me, Mr. Albano, I have one question that's a little off what you're arguing right now, but in your Rule 16L letter, you're not suggesting, I assume, that the new United States Supreme Court decision would be applicable to your case, because it happened, your case was long before this decision was decided.
I think the outcome of this case doesn't change regardless of what the court does with respect to Twombly. And I suppose you're right that unless the court said this is really what it's always meant, that we're just clarifying what 12b-6.
Which I think it may be. And in any event, it's the 12b-6 of the Superior Court who, whatever the standard was at the time, agreed that there should be a dismissal of the case.
Right.
Correct? So,
well, that's what I'm saying, that this new standard wouldn't apply because we're
well, it's not, if it's a new standard,
well,
from the Superior Court's judge's point of view, you fall well within the standard. Let's say it's a more stringent standard for plaintiffs or a more lenient standard for defendants, whichever way you go. You're within it.
Yes. I mean, may be blunt. We can live with and we're happy with the Conley standard.
That's what I'm saying.
Can I ask you this, though? I mean, you focus on so much on the fact that Putnam had a right under its plan not to purchase these shares if they were tendered. But, I mean, isn't the proper focus on whether or not Mr. Eigerman had a right to tender them? He had a contractual right to tender them twice a year or within whatever window. I think it was twice a year. And his complaint claims that Putnam interfered with that right by, in essence, threatening him with loss of job should he do so. I mean, why isn't that a claim, an interference with the contractual right?
I think in the end, all roads lead back to the provisions that say that Putnam had no obligation. Here's why. He first says, I was intimidated and coerced, so I didn't tender my shares. Well, a claim of coercion and duress can be a defense to a contract action, but it doesn't give rise to a contract action.
But if you give someone a contract right to do something, and then you say later on, and the person signs the employment or signs the agreement, and then you say, but you know what? I didn't tell you this. But if you exercise that right, you may get fired. I mean, isn't that a breach of the good faith and fair dealing provisions that go with every contract at a minimum?
No, it's not a breach of the covenant of good faith and fair dealing for two reasons. First of all, those claims in an employment context have never been recognized unless the conduct included a termination of the employee.
Wasn't
Isn't
that
that the-
implicit, though, in this? I mean,
No,
here's our policy, we've got a new policy now, and we don't want you to do this.
If you make the generous assumption that I'm prepared to do, that the memo could reasonably be read that way, I say two things. First of all, he wasn't terminated, so he has no claim. Secondly, let's assume he was terminated. It still would not have been a violation of the covenant of good faith and fair dealing. This court's decision in the King case, King versus Driscoll, employee is terminated for participating in a shareholder derivative suit asserting rights under a stock buyback agreement. And this court holds that's not, that doesn't give rise to a wrongful termination
But that's
claim.
a different situation. I mean, if you're participating in a shareholder, I mean, I think we're getting a feel, but participating in a shareholder derivative suit against the corporation seems different than exercising your contractual right to seek to redeem your shares.
Well, the similarity would be that in King, the plaintiff was asserting his rights under a stock buyback agreement, got fired for it, no cause of action, no violation of the covenant of good faith and fair dealing.
You seem to be assuming or conceding something that isn't that you don't necessarily have to concede. I don't see. I mean, where is the threat in this letter that you'll be fired?
There's, I do not concede that, and as I said at the outset, we say that that letter, with the absence of any, that memo, in the absence of any other allegation of threats, phone calls, emails, whispers, is not sufficient as a matter of law to state a claim.
Let me ask you this. I understand the persuasive power of King against Driscoll for these facts, but let's assume that the letter, the January 28 memo of Mr. Lasser, contains no threat of termination. But what it does, reading, giving it a very broad reading, it suggests that you shouldn't, for whatever set of reasons, tender your shares, right? You shouldn't tender your shares. Why is that in and of itself not sufficient to be a breach of a covenant of good faith and fair dealing? That's a different way of asking Justice Cordy's question, I think.
Well, I think, again, there's two reasons. One, we still have no termination. Two, what the memo says, we want you, there's an informal policy to hold your shares, and you need to talk to the operating head before you sell them. Let's step back. What the plan says in multiple places is,
if you tender them, we don't have to.
Right. So think of this. Would we construe that plan to mean what the company is saying when they come up with this plan is, we have no obligation to buy. By the way, Mr. Eigerman signs a document saying he represents and warrants that he gets that he knows there are restrictions on the share. But stop there. We put these provisions in the agreement, but God forbid you the company, ask an employee before you decide whether or not you will exercise your discretion to buy. God forbid you ask the employee why he wants to sell. You don't have an obligation to buy, but God forbid you say to the employees, we really don't intend to buy unless there's certain circumstances are satisfied. Those are not breaches of the plan. That's simply the exercise of the discretion that's afforded under the plan to decide whether or not to buy. That's why I say all roads lead back there. What the claim really is a claim that his right to tender was interfered with by Putnam. But Putnam can't interfere with its own contract. There's no conceivable interference with contractual relations claim between the two parties to the contract.
So his whole case depends on his interpretation of that Lasser memo? Is
Yes,
that a fair
it's-
statement?
Well, it depends on two things as far as I can see. It depends on his interpretation of the Lasser memo and ignoring the provision in the contract that says that you don't have to buy.
Right. You have
Because
to.
what's the measure of
But
damages here?
he has nothing from anybody else in the company, operating head, anybody else that says, look, if you tender your shares, we're going to fire you.
Nothing.
He doesn't have that.
Absolutely nothing. It's the Lasser memo
The
and
Lasser
only
memo
the
looks
Lasser.
to me to be perfectly benign. Look, we have this policy, but, you know, it's optional, and we really want to know why you're doing it so we can track the equity sales, and we're only going to do it for good reason, like you got to pay your taxes or you need to buy a new car or something like that.
And if I could add, if you don't put a limit to claims, and this is a putative, they want to certify a class. If you don't put a limit on claims that can be brought based on the way people psychoanalyze or divine meanings from a memo, where does that end? The memo could have changed.
The interpretation of the memo isn't his far-fetched interpretation. It's what a reasonable person would interpret the memo as.
Which I say presents a threshold issue of law for the court. Is that interpretation of the memo advanced by Mr. Eigerman a reasonable interpretation? Could a reasonable person, based only on that memo, see that as threatening? We say no, couldn't be.
And he wants this to be a class action?
That's right. There's three, it says there's,
How many possible people could be in this class?
his complaint says 300 shareholders are in the
Albina,
class.
could I ask, well, first of all, so the nub is really the appeals court holding that the timing, the context of the memorandum, coupled with its statements that while the plan's goal was established, I mean, you know all this, it was a long-term incentive, permit the inference at this stage of the proceedings that the Lasser memorandum unfairly deterred Eigerman from tendering his shares. It's your position that even if that were the case, the motion to dismiss should have been allowed.
Yes, yes. If you want to take the, as I say, very generous assumption that there's something intimidating about this memo, there's no breach of contract claim. There's no provision identified that prohibits the company from issuing a memo like this. There's no provision in the plan that says you can't be asking people why they want to sell. You can't be telling people this is a long-term incentive. There's no breach of contract in that setting at all.
Maybe the company wants to know why people are selling in order to make a determination whether it's going to continue plans like these.
That's
Whether
right.
It's going to continue to offer stock.
And just simply wants to decide whether, in weighing the financial costs of buying the stock, is the reason advanced by the employees sufficient for the hit that the company is going to take if it decides to repurchase?
Well, all that's interesting, but that precisely all that inquiry is cut off because this case has been dismissed. So none of these things will be known. We don't know whether the company, in fact, intended to threaten its employees very directly with their jobs if they tender their shares. We don't know that.
But it's been dismissed because no reasonable person could interpret that memo as a threat.
I would, yes, I would say, Your Honor, that's the threshold answer. It can't be reasonably interpreted. But again, if you want to assume that it can be interpreted, there's still no cause of action. Could I add
Well, you
one?
don't have to go that far, though, do you? I mean, in other words, I mean, I guess that if someone, I agree with Justice Cowan that this complaint is not reasonably read to think there's a threat of termination. But if someone were terminated for tendering his shares, when you have a signed agreement that permits him to tender his shares, it seems to me that's not a road you want to go down and say that's not a breach of contract.
Well, there is no provision in what the plan actually says is that nothing in the plan alters Putnam's right to terminate participants' employment, and nothing in the plan gives them a right to continued employment. In Harrison, the court held if you terminate someone and you want to stop them, this was the motive, you want to stop them from exercising an option, okay, it's not a violation of the covenant of good faith and fair dealing. This is just another wrinkle on that
But
same
in any event,
doctrine.
in any event, we don't know that. right? We don't know. Even if there was discovery, what we're going to do? We're going to ask Putnam, would you have terminated had he tendered? And Putnam says one of two things, yes or no. How do I know that that's correct? I have no idea.
No, I'd say discovery won't change anything in this case. We could take discovery, certify a class, engage in 5 years of
Mr. Albano, I mean,
litigation.
that's all very interesting, and then again, it might. There may be a memo that says we need to stop employees from doing this because it reflects badly on us. We can't directly come out and say we're going to fire people, but let's make it quite clear that that's what we're going to do. We can use good words. We have good lawyers. People will understand what it is that we're talking about. Let's go forward and do this because we don't want employees to exercise their contractual rights. What if that memo's in there?
That's why when Justice Botsford says I don't need to go that far, I'm going that far to address that question.
Okay.
If that memo's found, and if that action is taken, it is still not a violation of the covenant of good faith and fair dealing. There's been no termination, and it's totally consistent with the court's decisions in King and in Harrison. If I could just say one other, if I may, that if you read through the complaint, here's the heart of what Mr. Eigerman says, because he has to deal with this fact that the plan keeps saying no obligation to buy. He says, you know what, though? If I tendered, Putnam would have had to buy because they would have felt pressure from negative business press.
But that's not in the complaint. There's no allegation in the complaint about that.
It's in the pleadings considered by the motion judge. There was an affidavit filed by Mr. Eigerman.
But this wasn't treated as a 12C motion, was it?
No, it was. It was not.
It was a 12B6 motion.
There is a subtlety there. Yes, absolutely yes. However, I should say this. The court did read the affidavit, and I'm not talking now about just reading the plan, which certainly falls within traditional 12B6 analysis, but he actually considered an affidavit filed by Mr. Eigerman and said, that doesn't change my analysis. So in another sense, there was a Rule 56 aspect to the decision. But I just wanted to say this. If you boil down his claim, he says, I wanted to force them, coerce them, to buy my stock because they were going to be afraid of negative business press.
Mr.
And before
Albano,
I could do
your
that.
time is up.
Thank you.
Mr. Eigerman?
Thank you. Let me start where my brother left off. No, there was nothing in Judge Spina's question. No, that isn't in the complaint. The complaint alleges a breach of contract because there's an absolute right to tender, and they were interfering with that right.
He never tendered.
Now,
But he never tendered.
I'm sorry?
He did not tender.
No, he didn't tender at that point. Of course not. But let me
No, he
continue.
didn't tender.
I'm sorry?
He did not tender.
No, he...
Nobody told him not to tender.
Oh, yes.
Who told him not to tender?
Mr. Lasser in his memorandum
So
said,
if I read the memorandum saying, don't tender, as opposed to please come and talk to me before you tender.
well, what is wrong with this memorandum? It seems Well, I'll go perfectly through it. within the company's authority to issue this I'll kind be of happy to memorandum. go through it. First of all, again, we mustn't forget this is a motion to dismiss.
I understand.
I know And it, but you still got to have In something. a question whether this were libel or anything else, the question about whether a document is susceptible to interpretation depends
On a reasonable person
on
reading
a
it.
reasonable person, or depends on context and
Yes, we've
understanding.
got context.
Yes.
We've got
Now, in the
context.
context of this company, first of all, the memorandum, first of all, changes, as the appeals court noted by italicizing this portion of the memorandum, changes the prior understanding of the plan. Mr. Lasser, when the plan was promoted, said it's for short-term as well as long-term gain, and now he's saying it's our informal policy not to do that anymore, whatever informal means.
It means informal.
It certainly seems to mean that they're
It
going to
means-
follow it.
No, it means that if somebody tenders, had somebody tendered, it seems to me that you have to show that there would be an adverse, at minimum, you have to show that there would be an adverse employment action if somebody discussed, not whether or not you were persuaded not to tender,
Well, I believe actually what I'd have to show is that a reasonable person, knowing the context and in that situation, would take it as a threat of.
And what language do you point to? Not just generally, what language in the memorandum do you point to that says that this is a threat of what? Termination?
A threat of adverse employment action, perhaps termination. Who wants to run the risk?
And where, hold on, Justice Cowan. And where, hold on. Where do you see that? Point me to the language. I'm trying to understand.
First of all, there is a statement that says that tendering your shares to pay the taxes or to meet some sort of financial emergency is acceptable and will not be questioned.
One example might involve taxes. One example might involve taxes. It doesn't say it will not be questioned.
It says, again, let me read it. Why should we depend on memory? A sale of this type is acceptable and will not be questioned, unquote. Now, I'm sorry, I think logically that means...
Doesn't that mean that no question it will be redeemed? I mean, you'll get a payment for it, whereas if it's something else, we may not choose to buy it back.
No. Again, there is nothing in this memorandum that suggests at all that they are going to exercise their discretion not to purchase. That's a red herring.
No,
that's nowhere in their thinking.
Why is it a red herring when they already have that contractual right?
Because they dare not exercise that contractual right for two principal reasons. One is that it's a close corporation and they cannot discriminate among their minority shareholders. And the second is that they know.
Are you saying that that provision in the contract is void?
I'm sorry?
Is that provision that gives the company the right not to buy back if there is a tender is void?
No.
Well, how...
But like everything else, it's subject to the law of the Commonwealth, which includes the doctrine of Rod Electric, which means they cannot discriminate among their employees in redemption.
It might be, for example, that, employee 1, 2, 3, 4 tender, and the company decides for business reasons that that's okay, and they buy back, and then employee 5 and 4, some reason the company, I don't understand what the discrimination is. At some point, if they have the legal right to decide whether or not to buy back, by necessity, that is, quote, a discrimination.
Well, it does not say, first of all, even if it were, it would still be affected by the doctrine in Rod Electric type. They couldn't by agreement agree a minority shareholder he agrees to be discriminated against.
Mr. Eigerman, how do you deal with our holding in Harrison that says you can actually fire somebody?
What, the King case?
No, Harrison.
You fire, so
okay, if you're not familiar with the case, it's
the
fine.
King case, for example, I think is plainly distinguishable because there the plaintiff was fired for bringing a derivative action. He was not fired for doing something he was entitled to do under his employment contract. In this case, the issue was the employment contract.
Yeah, but nobody's been fired.
I just don't see any coercion in this memo at all.
Well,
again, I
haven't been able to follow my thought through, but it does say that there are reasons which are acceptable and will not be questioned.
Yeah.
And by, I think, inevitable logical implication, there are others that will be questioned. And it doesn't say we won't buy your stock. It says before you offer your stock, come and talk to your operating head. And again,
perfectly fine to me. I mean,
well, it seems perfectly fine, except if you take the the culture of the company in which you would not willingly talk to the operating head even if you had something nice to say.
How do we know about the culture of the company?
Well, we don't, because this was a motion to dismiss, because I was never enabled to expand on any of this. And the motion judge, as Mr. Albano pointed out, yes, he read the brief in which I raised these issues and the affidavit, and he dismissed them because he said it was a matter of parole evidence, that he wasn't going to look beyond the language of the
complaint,
of the plan. So the fact that I suggested reasons why this was a intimidating memorandum, that was not part of his decision at all.
Well, why should it be if we're dealing with a motion to dismiss? We're limited to the complaint, aren't we? Does the complaint talk about the culture of the company and operating?
It says that all the employees understood it to be intimidating and a threat.
The complaint says that?
That's what the complaint says.
Mr. Eigerman, may I ask you this? I'm reading from, I believe, the complaint, at least it's in the record. It said there had been a comparatively large-scale redemption of shares, which is precisely when I think entities who have reserved to themselves the right not to buy back every time there's a tender may well be such an occasion. It just so happened, unfortunately, the first 6 employees had a buyback and then the 7th didn't. But it says the defendants determined to deter their employees from future redemption. So even giving the Lasser memorandum that reasonable reading. Then you say in contravention of the provisions of the plan.
Well, the plan provides an untrammeled right to tender. And again, the company never said, we won't buy back your shares, because it couldn't. And Mr. Albano suggests, I'll tell you why it could not. It could not as a practical matter. And Mr. Albano says, oh, the plaintiff here is trying to coerce the company. It had nothing to do with this plaintiff or any other individual class member. If the company had said, we have had so many redemptions in this last period, and it looks bad, and therefore we're not going to redeem anybody's stock except for hardship this next window, the chance that that would not be leaked to the press by somebody and that it would not have opened up terrible adverse publicity is precisely the reason I believe, and I have not had an opportunity to investigate by going through the emails and the memoranda. Why did they do it this way? Why didn't they simply say, if we don't like your reason, we won't redeem it? For a very good reason, because they knew they could not refuse to redeem as a practical matter. And therefore, their interference with the right of the employees to tender deprived them of something of value, namely the right not to be forced to hold stock as it plummeted.
Leaving that aside, so I understand what the in contravention of the provisions of the plan are. You said that you have an untrammeled right, and this was an interference of that. Then you say, and of the employment agreements. What are the employment agreements that have been contravened by the defendants deterring their employees from future?
I apologize. One writes a complaint very much at the beginning and tends not to read or reflect on it many more times. I don't, standing here, know precisely what I'm referring to. My understanding is that there is I don't believe that this plaintiff or other plaintiffs had written employment agreements, but I may be mistaken. I don't know. I'm sorry. I don't know.
No, that's fine. I just want to know that I understand. So
yeah, I don't think there's anything beyond that at this point.
And, you know, I'm not trying to nitpick. I'm trying to really understand the claim. Your view is your client had, I think your words were, an untrammeled right to tender.
Yes.
And that the employer, Putnam, sought to interfere with that right,
Yes,
and it did it in the Lasser memo,
yes.
that in the context of that company could only be understood by those employees, that if they discussed the memo with the operating head, they would have adverse employment consequences.
Well, I don't think discuss it, but if they have a reason which isn't approved of, namely, I want to get out of the stock before it becomes even less worth anything, and if they insist on tendering after that conversation, then presumably they will have adverse consequences.
Can I ask you this? I'm not sure I understand that the stock is given to the employees, right?
Yes, it's not an
Is
option.
it part of their compensation?
I believe so.
They get a W-2 or a 1099
Absolutely.
or something. They have to pay
get a
taxes
W-2.
on it.
And they pay taxes at 100% of the value.
And they can't sell it in the market.
Cannot sell it in the market, has no market.
So
They're only operative, they can offer it to the company, and if the company declines it, they can offer it to other members of the
can
plan
try to
who
sell
are
it to
hardly
other
likely
employees.
to buy it.
So
And
in
your
order to
client knew-
realize any benefit from that, they have to be able to sell it.
Yes,
I mean, they've been given it by the company annually as part of their compensation. They pay taxes on it, but they can't redeem it unless the company, in essence, buys it back from them.
Or
Now, the
somebody
company
else
has
does.
to buy it back upon termination of employment, whether it's voluntary or involuntary, don't they?
I don't know whether they have to.
No, I don't think so.
They always have. I don't recall whether they have to. Of course, they
There's no
always
cl-
have
there's no
redeemed
claim-
anybody's stock.
There's no claim that your client didn't understand what he was signing, correct?
No, of course he understood.
Okay.
That's exactly why he didn't tender. He understood it all too well. And again, in the moments remaining to me, let me just suggest that in order to find that this memorandum is not susceptible to the interpretation that the plaintiff has put on it, this court would have to conclude that there is no set of facts that I could prove, because I haven't had the opportunity, that would demonstrate in context what it meant to the people in that company. And I just don't think that this court can do that. However much less inflammatory one or another justice may think it is compared to what I think it is, I really think that's not it would have to be so plainly benign and without context, without a possibility of such interpretation, which, by the way, the appeals court had no difficulty in seeing that it could be read that way, whatever weight that has. My time is up, unless there's...
Thank you, Mr. Eigen.
Thank you.